Hey friends, it's your friendly neighborhood feminist lawyer again. One of the questions that I kept getting was, what's the difference between being detained and being arrested? And really the difference lies in what level of suspicion needs to be present. Being detained is something temporary for investigatory purposes where they can ask you some questions or they can do a frisk to make sure that you don't have any weapons. The only level of suspicion that is required for this is called reasonable suspicion. And the court defines this as something articulable, which is just more than a hunch. Pretty nebulous and really easy to argue. So they just have to reasonably suspect that you either just did, are about to, or are in the middle of committing a crime, or that you're a danger to them in some way. This is when they can detain you for a short period of time to ask you questions or to do a frisk for weapons. Now, watch my video on stop and frisk for some more information about what they can do if they pat you down for weapons. Reasonable suspicion is not enough for arrest and not enough for a search warrant. In order to do a full search or to arrest you, they need what's called probable cause. According to the language in Illinois v. Gates, the court must consider whether, based on the totality of the information, there is a fair probability that contraband, evidence, or a person will be found in a particular place. That's probable cause. And Maryland v. Pringle says the officer must have a good faith belief that a crime has been committed and that the individual he's arresting committed the crime. So this is how reasonable suspicion can give rise to probable cause. If they stop and detain you under reasonable suspicion and you keep talking and somehow admit that you were involved in some kind of illegal act, suddenly we have probable cause to search or arrest. If they pat you down for a weapon and, according to the plain feel or plain view doctrine, they plainly feel in your pockets something that's contraband or a weapon, then they can reach in and grab it, and that counts for probable cause for arrest. The smell of marijuana counts. This is why, even though if an officer only has reasonable suspicion, it's just a step towards probable cause to search or arrest. So number one, ask, am I being detained? Am I free to go? Number two, if you are not free to go and you are being detained, you need to demand a lawyer and then vocally assert your right to remain silent. Say, I want my attorney and I'm invoking my right to remain silent. And then stop talking. Do not answer questions until you have your attorney. Stay safe out there, friends, and keep fighting the good fight.